Hey, it's Carmen from Pacific Workers, and today I have another amazing video for you. If you haven't subscribed to our YouTube channel, make sure you hit the subscribe button now and hit the bell notification so that you can get notified every time we upload a new video for you. Joining me today is a former defense attorney that agreed to come on anonymously and share some of the secrets that help us understand why the California workers' compensation system is such a broken system. This is definitely one you're not going to want to miss.
I was a defense attorney for just shy of 5 years. Working as a defense attorney skews your vision of the workers' compensation system very conservatively. It makes you look at everyone as though they're trying to pull a fast one.
What exactly does a defense attorney really do?
The defense attorney, when brought onto a case, is brought on to help manage the claim just as though an adjuster does. And it can occur either when the injured worker obtains representation or not, if it's simply a difficult claim. But the goal is to push the case either for resolution or to shut it down, spending the least amount of money in as short a time as possible.
Wow. Now, how exactly do defense attorneys and claims adjusters work together?
It depends. Some adjusters tell the defense attorneys what they want, and the defense attorneys go out and do it. Some adjusters refer the files to defense attorneys so that they can be told what needs to be done, and they can remove their independent thought, and the case is then run by the defense attorney. So it really depends on the balance of the personalities between the adjuster and the defense attorney.
At any point, are the defense attorneys under any pressure to do something?
They are under pressure to retain their clients, so they need to make their clients happy. A lot of times you go down to the Workers' Compensation Appeals Board and you hear a defense attorney discuss with a judge, well, Your Honor, this is what my client wants me to argue. So it's very interesting in that it's not always the attorney's legal argument, it is the position of the claims adjuster at times.
What are some of the resources that defense attorneys use? What are some of the tools that they use sometimes in these cases?
They're very similar to those of a claims adjuster. They will use surveillance videos, they will use social media searches, background checks, what's called an ISO claim search, which is the voluntary reporting system. Very often in deposition, the defense attorney will come with an ISO claim search and ask about all of the matches for an address, social security number, and name of the injured worker to determine whether these past claims are in fact the same person.
Now, I'm curious to know, how is social media used against people in these cases, against the injured workers? You mentioned that earlier. What has been found? What do they dig for?
It's a balance in terms of what they are allowed to use in terms of social media. They can't friend the injured worker. That would be a deceptive practice. However, if there are pages that are public, even if the injured worker's page is private, a friend of the injured worker, a family member of the injured worker, it only takes one to have a public page with public view to see the posts that are shared with friends only. So it can be damning. It can show increased activity, increased functions of activities of daily living. It can show misinformation sometimes. It can show a snapshot because social media, particularly Facebook and various other social media sources, are just a snapshot in time. So the isolated picture can look a lot worse than the actual activity that was being performed. So these are then sent to doctors and then even shown to the judge after the doctor has had the opportunity to evaluate these pictures. And even if they're seemingly benign, some doctors take a lot of weight and stock into these both videos and these social media posts.
What are some of the things that an injured worker can do to protect himself or herself from these type of scenarios, from these types of searches on them?
Don't post anything during the course of your workers' compensation claim. If you do post something, it is potentially discoverable in terms of what's called impeachment evidence, to essentially say that you're telling the doctors and testified in the deposition that this is your functional limitation, but then we now have a picture showing you doing something else. So it is what's called impeaching your credibility, such that you may no longer be credible in your case.
Now, I want to dive into depositions. What are those, and how are those used to the detriment of an injured worker?
A deposition is essentially a question and answer session under oath where you are testifying informally. However, your testimony has the same force and effect as if you're testifying in a court of law before a judge. So that means your testimony is governed by the penalty of perjury, which in California is a felony. And in terms of workers' compensation testimony, it's typically making any knowingly false or fraudulent claim to obtain benefits. So, with that being said, if there's surveillance video or you have represented to a doctor that you cannot do A, B, or C, you then testify that you cannot do A, B, or C. The defense attorney could theoretically introduce the surveillance video showing you doing all of the above, A, B, and C. That would be really, really bad for your case because you now have lied under oath and you've lied to a doctor and they have it on video evidence and they can send that to the doctor. The doctor, typically the QME or even the primary treating doctor, will get involved and comment on that surveillance video, and then it can go to a judge. And typically it will have a very negative effect on your case. Depositions can also be used simply to get information, such as past injuries, past medical treatment, past surgeries, things like that that can offset the level of permanent impairment. It doesn't necessarily have to always be an all or nothing proposition, meaning is the case going to remain accepted or is it going to be denied? It can be as simple as a reduction in the available benefits to the injured worker.
Wow, that's quite something. So what does an injured worker do to protect himself or herself from a deposition? What if, say, the person can't remember some of the stuff that's being asked? How can they protect themselves?
Well, testify truthfully. If you're not sure of an answer, I don't know, or not that I recall, are both perfectly acceptable answers. Stay away from terms like always or never, because there's usually an exception to a rule, or a single time that, even though you say it's an always, that it didn't occur, or the one time you tried something that makes the never the single occurrence that is no longer a never.
Are insurance companies allowed to dig into your medical records? Can they get a hold of your records? And if so, how? And how do they use this against you?
The carriers are entitled to your medical records to the extent that this particular body system is at issue. Typically, if you plead an orthopedic only, let's say a knee injury, the carrier is not entitled to any past psychiatric or psychological records. However, if you plead a psych case, the carrier would typically be entitled to all of your medical records because it would all be relevant to your overall psych condition. So the reason why they are entitled to these records is because you have put your body system at issue. And that means that they can contest by way of obtaining these medical records. The records can be used to really send to doctors for a couple different determinations. One, whether you've had past injuries that could have an effect on your overall level of permanent disability in terms of apportionment. So if you had a shoulder injury right now and you had a shoulder injury in the past to the same shoulder, and maybe you had a surgery in the past, doesn't mean you can't have a new injury, but there will likely be some level of offset to the residual permanent impairment. So that is typically the main thing on an accepted case that the defense attorney is looking for when they take the deposition. Could also be additional body parts and things like that, but oftentimes it is this permanent residual impairment and the level of apportionment so that they can send it to the QME. The other thing that they're looking at is if there's a disputed body part, when, if ever, did these other body parts come into effect, so that they can also write the QME and or the primary treating physician. And lastly, they are looking for any evidence of past injury or continuous treatment to see if the case should be accepted or not, if there is potentially a new injury, or if potentially they can keep it as an old injury and offset 100% of the case to a prior injury or surgery or broken bone or something to that effect.
How often is this actually used against an injured worker? Is it more often than not?
In terms of apportionment, it's a very regular occurrence. People live their lives, people have injuries, people have aches and pains, particularly those who work in heavier occupations. In terms of prior injuries, it really depends. If somebody did have a prior injury that was severe enough to keep them outside of the workplace for a period of time, or resulted in a surgery or something like that, it's extremely common. It's less common in terms of being able to maintain a full denial of the claim, because the threshold for injury in California workers' compensation is relatively low.